Step right up, step right up, step right into another amazing show. And trust me, you will adore today's show. Yes, you. Auntie Miracle B is live on YouTube right now. B.
Yeah. Happy Wednesday. Happy Wednesday. Welcome, welcome. Today I am bringing in my part two of the Darrell Brooks unlawful law was the case that they gave me, where he continues to act a fool and is going to continue to play ignorant. But this is where the judge allows him to uh, fire his counsel. He represents himself. So we're going to get into it, and I'm going to break it down from the sovereign citizens SovCit shit and uh, and amuse ourselves.
Mr. Brooks, I do have in front of me a waiver of right to attorney form that was electronically filed into the case today. I'm going to pull it up. You acknowledge, sir, that it is before you on the screen.
Yeah, I can see it.
I don't want to make any assumptions, sir, about who filled out this form and how it got to me. So I'd like to ask a few questions about it. I, of course, gave you this form at the end of yesterday's hearing. Hold on a second.
So the form that she's referencing is a state form of the waiver of right to counsel. So she's continuing that colloquy, trying to make sure that this idiot is fully informed and aware, and he is making this decision. So he cannot come back and try and appeal and say that he had an unfair trial because he didn't have assistance of counsel.
The live stream, it's the feedback we get because I'm displaying my computer. So give me a second. I'll do it a different way.
Oh, look, they showing the form.
Should also be on the share screen. Are you able to see it in front of you as well?
Look at this here.
I did a test with this yesterday to see if I shared my screen, how it would come up on the live stream.
It's the whole form right here. Waiver of right to attorney.
That's all right. I'll stop the share screen. Mr. Brooks, if you want to confirm with me that your attorney has put in front of you the original.
Excuse me, say it again.
Sure. Could you please confirm that your attorney placed in front of you the original waiver of right to attorney form that you filled out?
Yes, right.
You acknowledge,
Hey,
sir, that
James.
I provided this form to you at the end of the hearing yesterday.
Yeah, I'm getting this.
I filled in certain information on this form regarding the caption at the top. That's the part that's typed. You acknowledge that.
Which part are you referring to?
So the very top of the form is a caption where it says State of Wisconsin versus Darrell E. Brooks, and there's typed written information. I'm telling you, I filled that out. You would agree with that?
I didn't see you fill it out.
I didn't
So
see you
when
fill it
you
out.
obtained, when I gave you the form, was that portion of the form
Wait, hold
filled
on.
out with typed written information?
I got it up as high as it'll go. Let me see. I need Vic. He can, let's see, audio. Let me see. Virtual background. It won't let me turn it up any louder. Mirror my camera. No, that's not it. Audio. So it's my mic. Default headset. Yeah, I can't turn it up any louder. This is loud as it is. Unfortunately, I'm sorry. But I will mute myself. Maybe that'll help.
Yeah.
All right. There's a section further down that says crimes and penalties. Do you see that?
Yeah, I see it.
When I gave you this form yesterday, was that section or both of those sections actually filled out with typewritten information?
Yeah.
And that's the information that's on the form in front of you. Is that correct?
Yeah.
If you turn to the second page of that document, there's a signature box. It has a number of lines. Do you see that?
Yeah.
And there is one line where it says name printed or typed with the name Darrell E. Brooks typed in. Do you see that?
I see it, but that is not the way my name is. I
Sir,
don't acknowledge
do you
that name.
acknowledge, just listen to me, sir. Do you acknowledge that when you received the form, that printed name was on it?
I recognize that there is a name printed on it. That is not mine.
Sir, the form that you have in front of you, which has a lot of other information on it, did you fill that out?
I filled it out a certain type of way.
Listen to me, sir. Did you provide the handwritten information on this form?
Yes.
I want to confirm the information that you filled out. My understanding, you are 40 years of age. Is that correct?
Yep.
It's also my understanding that you completed 11 years of schooling. Is that correct?
Yeah.
You have either a GED or an HSED. Is that correct?
Yes.
Do you know which one?
The HSCD. I
Thank
said that yesterday.
So he said, so here he is getting smart with the judge. Tell me something. He got an HSCD. And I said that yesterday. He's a high school equivalency diploma. I said that yesterday. I said that yesterday. I hate people like this. These are people get on my nerves.
Right. I've read in other materials that it was a GED. That's why I'm asking you.
I'll clarify it yesterday that it was the HSCD.
Thank you. It's also my understanding that you are able to read, write, and use the English language. Is that correct?
Yes.
Lies.
English, as I understand it, is your first and only language. Is that true?
Yes.
Further my understanding, sir, that you are not currently receiving treatment for a mental or emotional problem. Is that true?
Not currently.
Is that true?
Not currently.
Did you hear my question?
Yeah, I heard it.
Is it true that you are not currently receiving treatment for a mental or emotional problem?
No.
That question is important because she has to figure out if he is suffering from some sort of mental defect. And remember, he did originally plead not guilty by reason of insanity. So he had to be evaluated anyway.
It's not true.
Say it again.
Is it true that you are not currently receiving treatment for a mental or emotional problem?
Yeah, that's true.
You also have checked that in the past you have received treatment for mental or emotional problems. Is that true?
Yes.
Further my understanding, sir, that you have not had any alcohol, medications, or drugs within the last 24 hours. Is that true?
Yes.
It's also my understanding, based upon how this form was filled out, that you do not have any physical or psychological disability that may affect your ability to be informed what is happening in court or communicate your position or views on the case to the court. Is that true?
Yes.
We talked a little bit about this yesterday. You graduated with an HSED, as we've talked about, right?
Yeah.
You've been able to read the various documents that have been provided to you in this case. Is that true?
Yeah.
You're able to write. Is that correct?
Yeah.
Let's go down to the next section, sir, where it says, I am informed that I have been charged with the following crimes that carry the following penalty. Do you see that section?
Yeah.
I
Hey,
want to
Kayla.
advise you of the following. I want you to listen to me. You are charged with 6 counts of first-degree intentional homicide, use of a dangerous weapon. Each one of these counts is a Class A felony, punishable by life in prison, plus an additional 5 years for each count. Are you aware of that, sir?
I am informed. Yes.
See how he's answering? I'm informed.
You are also charged with 61 counts of first-degree recklessly endangering safety. Each one of these offenses is a Class F felony, imprisonment of not more than 12 and a half years plus 5 years for the enhancer for use of a dangerous weapon for each count if convicted. And you are aware of that, sir.
Yes, I'm informed of that. Yes.
There are also 6 counts of hit and run resulting in death. These are Class D felonies. Imprisonment of not more than 25 years for each count. And you are aware of that as well.
I am informed. Yes. I was under the impression that it was a certain type of way in the wording.
Sir, you are also charged.
So he thinks that he can take one of these forms, and you saw a little picture of it before. He thinks that he can take the form and alter it and make handwritten changes to this state form that's generated by the government. And he thinks it's like altering a contract. Like if you have a contract, you have to have a meeting of the minds and you write out everything in the contract, and you can alter it by making changes. Um, he thinks that this is some sort of, as he loves to say, tacit agreement. So that's what he thinks is happening, but that ain't the way that it works.
Charged with 2 counts of felony bail jumping. These are Class H felonies. And upon conviction, you may be in prison for not more than 6 years for each count. Are you aware of that?
I am informed.
I'm informed.
And then there are 2 counts of misdemeanor battery. Those are Class A misdemeanors, and upon conviction, you may be in prison for not more than 9 months. Are you aware of that?
I am informed.
I'm informed.
Have you been informed, sir, regarding the total exposure if convicted of all counts as charged across these 77 counts?
I am informed, yes.
Are you informed, sir, that as to the intentional homicide charges, use of a dangerous weapon, that if convicted, you could be sentenced to 6 life sentences consecutive to one another?
I'm informed.
Do you understand? Strike that. Are you informed, sir, that you could be sentenced consecutively on each one of the counts for which you are convicted?
I'm informed.
It's a tacit
For the
agreement.
first-degree reckless and endangering safety charges, without even the enhancer, are you informed that the maximum exposure is 762 and a half years?
I'm informed.
You see his body language here? He's just calm, cool, and collected when he was just told that he can potentially be sentenced to 762 years. He's just chilling. The prosecution looked more nervous.
Are you informed that when adding the enhancer, it adds an additional 305 years?
I'm informed.
An additional 305 years, 762 years plus 305 years. No visible response, no tension, no nothing. I'm informed. Okay.
You informed that the hit and run resulting in death charges carry an exposure of 150 years.
I'm informed.
An additional 150 years. I'm informed. I would be having a baby at the table right now, hearing all those years.
Are you informed that the felony bail jumpings carry an exposure of 12 years? Are you informed, sir, that the exposure for the 2 Class A misdemeanors is 18 months?
I'm informed.
You informed, sir, that all of the charges stem from an incident that is alleged to have occurred on November 21 of 2021 in the city of Waukesha.
Is it on the sheet?
Sir, did you hear what I said?
I thought I was following the sheet. That's why I'm looking.
Sir, did you hear what I said?
Oh, I did.
So, as you can see, what he likes to do is he loves to play ignorant. That is part of what the Sovereign Citizen Manual instructs them to do, to play stupid, but to be smart. But of course, he's neither. Well, I mean, he is stupid, but yeah, yeah. Like, nigga, you heard
Did
her.
not hear what you said.
You heard her.
Are you informed that all of the charges stemmed from conduct that is alleged to have been committed by you on November 21 of 2021 in the city of Waukesha?
I'm informed.
Are you further informed that all of this conduct primarily relates to what has been referred to as the Waukesha Parade incident?
They worded it as a different way. They call it an attack.
I don't know who they is, and I don't frankly care.
What
Listen
difference
to
does
my
that make?
question, sir. Did you hear what I just asked
No,
you?
I'm not informed of that. This has never been referred to.
Sir, I am advising you that your conduct that is spelled out in the second amended criminal complaint, which this court provided you with yesterday, accuses you of committing multiple offenses during the Waukesha Christmas parade. Did you hear me say that?
Yeah, sir. Thank you for correcting the language.
Freaking asshole.
The next part of the form, sir, and I will return to it, is entitled, I understand I have the right to. Do you see that?
Mine says I am informed.
Sir, form, listen to my question. Do you see the section of the form that is entitled, I understand I have the right to?
Mine says I am informed.
So we're being difficult. He changed the I understand part to am informed because remember, like I told you, if you say that you understand something, that means that you made a tacit agreement and you have just given the court authority over, you've given them jurisdiction. Look, she's got the patience of a saint. I would be irritated. I would have already got up. He would have, look, he would already be able to have grounds for appeal. I would have lost it on him. I cannot stand people who act like this. I, oh, oh, it gets on my nerves.
You're not listening to me, sir. I'll get to that. But the form, the state form has a section that is titled, I understand I have the right to. Do you see that?
Yeah, I see it.
Oh, he sees it now.
You changed the word I understand to I am informed. Is that true?
Yes.
I'm going to advise you of the following. I want you to just listen. Sir, you have the right to have an attorney represent you at all stages of the proceedings. You have the right to have an attorney appointed for you by the state public defender if you do not have the money to hire an attorney. You have the right to hire your own attorney at your own expense. You have the right to ask the court to review a determination by the state public defender that you are not indigent and able to hire your own attorney. You also have the right to ask the court to find you indigent or partially indigent and appoint a court-appointed attorney for you at county expense if you have been found not eligible for a public defender. You also have the right to represent yourself and act as your own attorney. Did you hear me just now, sir?
Hey, Risa.
There is a line underneath those advisements that says, check this box if you read and understand the above. On the form that I have, the word understand is changed to am informed of. Is that true?
Yes.
The box is checked. Is that also true?
Yes.
Did you check this box?
Yes.
The next section of this form is titled, I understand an attorney would. However, on the form that I have, the word understand is changed to am informed. Do you see this section of the form, sir?
Yep.
Did you change the word understand to am informed?
Yes, I did.
I'm going to advise you of the following. I want you to just listen.
Now, let me just throw in here why this is important is because she's going through this form meticulously to make sure that he is fully aware and understands that when he waives his right to counsel, he is going to represent himself by himself. She's trying to get him to understand this and to make this to where he cannot claim on appeal he was not given a fair trial and he did not have assistance of counsel. Um, he's going to complain very soon that he's by himself, uh, doing stuff on top of the dome, winging it, that he has no help. He doesn't have the ability to get all of the documents and go through all of the boxes of discovery and the electronic discovery, and he's in a cell and he's this and wine, world's smallest violin. I'll get to that on another day. But that's why this is important because she literally tells him this in a roundabout way. Well, actually, she tells him explicitly, this is what it's going to be. This is what it is. If you do this, you're going to be by yourself. He said he cool with it. Okay. With over 1,000 years on the line, he cool with it.
You are advised that an attorney would represent you and speak on your behalf in court.
And baby, the way that you acted a fool, you needed that attorney to speak on your behalf in court. This is the poster person of say less. Hey Nola girl. Hey low value man. This is the prime example of say less. You probably would have came out much better.
An attorney would also advise you about your legal rights and options. An attorney would explain and assist you with legal and court procedures.
Now, another thing, you just heard her say that an attorney would help with legal and court procedures. He's also going to whine and complain that he doesn't know and he doesn't understand anything that's going on. He doesn't understand the cause and nature of the charges, but that's some sovereign citizen talking points. But he doesn't understand anything and he's confused. He says this over and over and over and interrupting the court proceedings, talking about I'm seeking to understand because I don't understand, asking all these questions. And the prosecution nor the judge can give him legal advice because you're your own attorney.
An attorney would help you negotiate a settlement of your case with the district attorney. An attorney would investigate and explore possible defenses to the charges against you that may or may not be readily apparent to you. An attorney would prepare and conduct a defense on your behalf at any motion hearing or trial. An attorney would file motions on issues of evidence, testimony, and procedures of the police. An attorney would assist you at sentencing if you are convicted of any crime. An attorney would also file an appeal if requested. Did you hear me just now, sir?
Yeah.
On the form that I have, there is a line underneath that says, check this box if you have read and understand the above. The word understand has been crossed out and changed to am informed of. Do you see that?
Yep.
The box is not checked. Do you see that?
Yep.
Was that an oversight?
No, it's a reason.
I'm sorry, I didn't understand what you just said.
There is a reason.
Do you sir, I advised you of what an attorney would do. Are you informed of what an attorney would do for you?
Yes.
Why did you not check this box?
Here it comes.
Because it is my understanding that representing myself pro per, I can have standby counsel. So that, in a sense, is why that box specifically is not checked.
That is
Did you look at the judge's face? She's just like, really? Where did you hear this stupid shit from? Look at the attorneys. Look at attorney. What's his name? Zach. Look at his face. Like, this is a dumbass. Even the paralegal is like, this is a dumbass.
not a correct statement of the law, sir. Standby counsel is not for the benefit of a defendant, it's for the benefit of the court.
Either way, it's still allowed for me to have.
Have you been advised, sir, that the public defender's office is not able to perform standby counsel duties?
No, I have not been advised that.
So the DA's office will not provide standby counsel duties. So he came and said, I'm going to represent myself pro per so I can have standby counsel, because he wants to establish himself as a sovereign citizen. And according to the guide, you have to represent yourself pro per, because if you represent yourself pro se, and that's PROSE, which means self-representation, then if you represent yourself pro se, you're going to be held to the same standards and rules that a licensed attorney would be forced to adhere to. But if you represent yourself pro per, you get to represent yourself, but you don't have to adhere to any of these rules, which makes literally no sense. I have never heard that ever in life, ever in life.
There is a rule that was promulgated by the Public Defender Board in Wisconsin that prohibits public defenders from
You're using big words, honey. He does not know what promulgate mean.
acting in the capacity of standby counsel. Did you hear me advise you of that just now?
Yeah, I heard you say it. What is it called?
You referenced standby counsel, sir. I'm advising you that the public defender's office is not able to act in that capacity. Did you hear what I just said?
I heard what you just said, and I asked you a question. Is that somewhere that I can find out about that information? Some type of.
Well, you do have two people from the public defender's office sitting right next to you. So I'm sure you can find out that information from them. I'm pretty sure they told you that, but you don't listen. Oh, crap. Hold on. I hit the wrong buttons. Oh, here we go.
Law or some type of.
If it is a law, you're not going to listen to it.
So it's an admin code.
We're going to get a bit of feedback, but I'm going to put it up on my screen, which the parties will be able to see. Sir, can you see what's before you on the screen?
Yep.
This is an administrative code provision, chapter PD5, adversary representation. I direct your attention to PD 5.03, prohibition against acting as standby counsel. Sub 1, no SPD attorney may act as standby counsel in any case. Sub 2, this prohibition applies whether or not the SPD attorney was originally providing adversary representation in this case. You see that, sir?
Yeah, I see it.
I'm going to take that down. This court, sir, you should be advised, would not be appointing attorneys Perry and Keys to represent you or to act, is a better way of saying it, as standby counsel in this case. Did you hear what I said?
Yes, and I didn't ask that. I didn't ask for them.
She's telling you that the two attorneys who worked on your case for a year will not be standby counsel for you. Your response is, I didn't ask for them. Oh, I'm sorry, axe, A-X-E, axe for them. The arrogance. You can see it just in his forehead. And these two are tired. They're tired. Look, the judge is tired already. This is amazing to
I'm
watch.
asking if you asked that, sir. I'm giving you advisements right now that you need to listen to. This court would also not appoint standby counsel in this case. Did you hear me say that?
That's fine.
This court is further advising you, sir, that this trial will start next Monday, October 3rd. Did you hear me say that?
I heard you say it, but I object to that.
How you object to it?
And I object on the grounds that are you making a judicial
Determination.
determination of that when you haven't even decided the issue while we're here?
Sir, I'm further going to advise you that at this late stage in the proceedings, which is frankly beyond the 11th hour, which is what the case law references, we are frankly at 11:58. This court will not appoint any other attorney to act as standby counsel if this court grants your request to represent yourself. Did you hear me say that, sir?
Is that the answer to the question?
Sir, did you hear me just now?
Is that an answer to the question?
This is not a question and answer session, sir. I'm giving you certain advisements. Did you hear me advise you just now?
Did you hear the question I asked? Because it sounds like a rush
Mr.
to
Brooks,
judgment.
we'll move on. You are advised
You are
that,
rushing to judgment.
Mr. Brooks, you are advised that this court will not appoint standby counsel.
Okay, you said that.
There
but
are
you
a
didn't
number
answer.
of reasons which I will advise you make it impractical.
You're not
This
answering
trial
the
is
question, though,
scheduled.
Your Honor.
Mr. Brooks, do not interrupt.
That is a rush to
Mr.
judgment
Brooks.
if you don't answer the question.
This is just a prelude of what is to come. Asking ill-timed, ill-conceived, stupid questions, interrupting the judge when valuable information is being given to him, completely incapable of nuance. There's a reason why there are people who are naturally able to be attorneys, and there are other people who should just be clients. He has no ability to see nuance. He has no ability to see analogy. You'll see that in the trial. He is completely just over the clouds, just as the carbonation folks would say, he's a surface dweller.
So
It's a
we
rush
are
to judgment.
here, Mr. Brooks, we are here because you want to represent yourself.
Yeah, but I didn't file the motion.
So it's not his fault, even though he's the one that wanted to represent himself. It's not his fault because he didn't file the motion. Because they love to blame shift. It's not my fault. I didn't do it. I'm only here. I was traveling. You interrupted me. I ran over you because you were in my way. I was honking the horn, but you didn't move fast enough. So I just ran you over. That's his logic.
That's
I'm just
not
merely- I'm
relevant,
just
sir.
merely
The motion is
asking-
before
I'm
me
just
and I'm
merely
going
asking-
to address it.
I'm
Stop
just merely
talking
asking
over
the
me,
question.
Mr.
That's
Brooks.
it. Just merely asking
I
the
need
question.
to get through the advisement.
And I would like to know the answer to the question.
You are being difficult. You are
Hey,
not
Stuff.
listening. You are trying to interject irrelevant factors for this court.
Get ready.
It has
So,
merit.
stop.
It's not irrelevant.
Stop.
I have a
Mr.
constitutional
Brooks,
right to
I'm
be able
going
to
to
ask questions.
continue. Please stop talking.
So it is arrested judgment.
Mr. Brooks. The case law makes very clear you can't waive your right to an attorney. Let me rephrase. Case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation while simultaneously exercising the right to counsel. Did you hear me say that?
Yes, I heard you say that, but that wasn't what I was attempting to do. That was the whole reason why I said it was filled out. This form was filled out for a specific reason, the way that it was.
So another thing about sovereign citizens, they have a magical thinking that if they write certain phrases down or if they say certain things, then that's going to automatically get them a win. They're going to outsmart the entire judicial system because they put the magical phrases down on the form. So that's what he keeps talking about. I filled it out a certain way because I wanted this, but that's not legal. That's not the law. But according to them, these flat earthers, that they believe that they can just put magical shit down and that flies and that applies. No, sir.
Sir, I'm not going to entertain a request for whether it be called standby counsel, hybrid
That's not what I'm talking
representation.
about.
Your attorneys have told me you want to represent yourself. That is why we are having this hearing here today. The next section of this form is entitled, I understand that if I represent myself, but on my copy, the copy e-filed in this case, it says, I am informed that if I represent myself. Do you see that section, sir?
What section are you referring to?
The section that is labeled, I understand that if I represent myself, but the word understand has been changed to am informed. It's on page 2.
This paper's got shuffled off the page.
Let me know when he has the correct page in front of him.
Okay, he's got it.
Thank you. Do you see that section, sir?
Now, what section were you referring to?
The section that says, I understand that if I represent myself, but the word understand is scratched out and it now reads, I am informed that if I represent myself. It's on page 2. Do you see that?
Yes, I do.
You are advised, sir, that the judge, that's me, cannot be your attorney and cannot give you any legal advice. You are further advised that the district attorney cannot be your attorney and cannot give you legal advice. You are further advised that the judge, district attorney, and court personnel are not required to explain court procedures or the law. You are further advised that the judge cannot treat you any differently because you do not have an attorney. You are further advised that you will be required to follow all legal rules and procedures that an attorney would have to follow in court, and that it may be difficult for you to challenge evidence presented by the district attorney if your case goes to trial. You are further advised that it may be difficult for you to present evidence. You are further advised that if you want to testify, you must be sworn as a witness and answer questions from the district attorney. You are further advised that it may be difficult for you to do a good job as your own attorney. Did you hear the advisements that I just read to you, sir?
Yeah, I heard it.
You are further advised, sir.
So she basically told him, you are going to be held to the exact same standards as the DA is. And the DA nor me are going to, we're not required and we're not going to answer any of your questions. So every time he starts whining about, I don't understand, I'm seeking to understand, can I do this? Should I do this? They don't have to help him. Him and his getting his subpoenas served, the DA volunteered to help him because he's incarcerated. And they didn't have to do that.
Sir, that acting as your own attorney may be very challenging. You would be required to participate in jury selection.
He didn't.
Including exercising preemptory strikes. It may be difficult for you to raise the issue of strikes for cause.
So what they're talking about is, before a trial starts, you have jury selection. And you do this thing, if you ever had jury duty, where they will ask jurors questions. That's called a voir dire. Ask the juror questions to try and determine if they have any preconceived biases. Okay. So if I wanted to have, if I was prosecuting, say, a black guy, and I wanted to potentially have a better chance of getting him convicted, I would ask certain questions that would give the color of not being racist, but it would show that there was a bias against black people, and I would keep them, right? There might, I don't want any black people, period. So you'll have like a certain amount of what they call peremptory strikes. So that means I can strike you for whatever reason, and I don't have to tell the court why. So if I want to be a complete racist asshole, I can just strike that black person, that black person, that black person, and they're just gone. Now, the strike for cause means I'm asking questions, and say I'm trying to defend a police officer, or not a police officer, someone who was beaten by the police. Well, I don't want to have a police officer or the wife of a law enforcement officer on my jury. So I'm going to strike them for cause. I'm sorry, that peremptory strike. I'm going to strike them because they might be prejudiced against my client because they have a history of law enforcement. So anyway, that's the preemptory strikes. Of course, he wouldn't know any of that because he doesn't have any legal education. And look, I have a law degree, right? But I've never actually practiced. I wouldn't attempt none of this shit by myself, period. Period. I wouldn't do none of this. I would be unprepared. And I know if I'm unprepared, you know he don't know nothing. And he has an 11th grade education and a failed criminal history.
At trial, it may be difficult for you to raise objections.
Oh God.
When to make them.
Oh God.
And how to make them, whether it be as it relates to the admission of evidence or the testimony of witnesses.
Well, we saw that. We saw he does not know how to make objections. He does not know when, where, how, and for what. My God, if you watch this trial, you know that he objected to every other question that was asked, and pretty much everything was hearsay, according to him. Because he thinks that hearsay is, I heard someone say something, and that's hearsay. and screaming grounds, grounds, grounds every 2 seconds. Oh, my God.
Other obstacles that you will face include applying the rules of evidence,
You don't know them.
understanding and applying the rules of trial procedure.
Don't know them.
These are things that are spelled out in the Wisconsin statutes. They're the law.
And guess what? She gave him the Wisconsin statutes and other rules of procedure and case law. Do you think he looked at it? Do you think he opened the book? Do you think he did? Nope. Nope. Not once.
You may face challenges when it comes to jury instructions, including when or whether to ask for jury instructions on lesser included offenses. Did you hear me advise you of these challenges, sir?
I did hear you advise me of them. I don't see them as challenges, Your Honor,
Yeah,
at all.
The court
you heard that? She said, I'm advising you about these challenges. He says, I don't see these as challenges at all. He got this. He got this. A millennium on the line. He got this. Don't worry about me. I got it.
must also advise you that I can make no guarantees about your access to legal materials while in the jail. Did you hear me advise you of that?
Yes, I did.
That's another complaint he had.
You may even find, sir, that if I allow you and honor your request to represent yourself, that once this trial starts, you may find it difficult and may even desire to change your mind. In other words, you may regret the decision that you make. I'm advising you, sir, that at that point, it would be challenging for this court to reinstate your right to an attorney.
So basically what she's saying is, this trial is going to start on Monday. Today is Thursday. This shit is starting on Monday. If we go and we start this trial on Monday, you can't say, I changed my mind, I want an attorney, because it's too late. No attorney is going to be able to jump in mid-trial and do anything because they had not had any time to prepare. So she's telling him right out the gate, look, you don't have time. If you do this, you are on your own, and it's going to be virtually impossible for us to, after you waive your right to counsel, to reinstate your right to counsel after you've waived it.
Did you hear me advise you of that, sir? Did you hear me, sir?
Now notice he's not listening. He's not responding. He's distracted. He heard everything else, but he can't hear this. Still hadn't
Yes,
answered.
did you hear me?
Yeah, I heard you.
Once,
Can I ask why would it
Once-
be challenging?
sir, let me continue. I want to advise you the following. When a person represents themselves, they are acting as their own attorney. Did you hear me say that?
Yeah, I don't agree with that.
He don't agree with that.
The case law says that rescinding a waiver of an attorney is no different than a motion seeking the substitution of an attorney. That is why this court is advising you it would be challenging for this court. I didn't say impossible, it would be challenging.
So basically, this motion to waive his attorney is no different than a motion to change out attorneys. And he is his own attorney. You see the distinction here? You see why this is a fucked up thing for him to do? So you're changing out, you're putting not even a bench rider in uh I don't know sports, but you know, you trying to put him on the starter. You got your starters already on the field, and then you're throwing in not even the bench rider. You're throwing in the water boy, the equipment manager. You tagging him in for the playoffs. That's in essence what he's doing right here.
There is significant case law on substitution of counsel and it falling within the discretion of the court. There's criteria discussed in cases such as State versus Lomax, State versus Boyd. There is case law that discuss 11th hour requests, which are generally frowned upon as delay tactics. The court would consider things like the impact on the court's general responsibilities for the prudent administration of justice. The court would consider whether requests like that interfere with the administration of justice, the impact to the court's docket in general, and other considerations, including the significant amount of time, resources, preparation that the court, the parties, even the clerk of court and the sheriff's department have put together to bring this case to trial in October of this year. Did you hear me advise you of all of these things, sir?
Yes.
Now, let me just say this. The reason why it was so important to have this trial in October, November the 21st would have been a year. It's a year since this idiot drove his car and killed and injured all those people. So she wants to get this done before that 1 year anniversary. That's why October was it. And they gave them a month to get it done.
There's a reason I'm telling you, sir, about some of these challenges and difficulties. And that is because I want you to know that waiving your right to an attorney does not mean the trial is delayed. Did you hear me say that?
That's not my reason for wanting to represent myself pro per. It had nothing to do with delaying the trial.
So you don't want to delay the trial, correct?
That's not
What I said.
the decision to represent myself pro per had nothing to do with a delay tactic.
Make no mistake, that's a delay tactic. Make no mistake about it. You want to play word games, it's a delay tactic completely. Because otherwise, you wouldn't be objecting.
I think I'm very
So-
clear with what I said.
Well, I want to be clear, I understand you, sir. If it's not a delay tactic, I take that as you're not requesting an adjournment of the trial. Is that true?
That's not what I said.
Are you requesting an adjournment of this trial?
I can't logically make that decision until you make a judicial determination. Why would I answer that question right now at this point when I still don't know what's been decided yet?
What the fuck does that have to do with anything? She wants to know, are you doing this as a delay tactic? Is your intent to delay the trial? Oh, well, I can't answer that question because you haven't decided on what we're doing. That's the point of this hearing. She's trying to determine if she's going to grant your request. And you're being a douche nozzle. Oh, Lord.
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
I heard you say that. And I
Knowing
still
that,
can't
sir,
I still can't logically answer what you are asking me because a decision has not been reached.
sir, what you need to understand is
Freaking
that the
idiot.
case law makes it very clear. You have the absolute right to represent yourself. That is protected by the US and the Wisconsin Constitution. Did you hear me say that?
I know that.
You have the absolute right to have an attorney represent you. That is protected by the US and the Wisconsin Constitution. Did you hear me say that?
I'm aware of that as well.
It is my understanding, sir, that based upon the motion that was filed, the waiver of attorney form that was filed, and the proceedings that have been held over the course of the last 2 days, you wish to represent yourself.
I wish to represent myself pro per, but I do not wish that my entire Sixth Amendment right not be honored. I essentially would only be agreeing to the part where I want to represent myself.
Okay, so you know what I find interesting about sovereign citizens? They don't believe in the government and that the state has no authority over them, but yet quoting the Constitution and the Bill of Rights. So basically, the Sixth Amendment just says in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. So I guess he should reserve that right by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been ascertained by law, and to be informed in nature and cause of the accusation. Uh, uh, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So he's saying he's going to waive his right to the assistance of counsel for his defense. So that means, though, you're going to have your speedy and public trial because we all watched it. Millions and millions of people watched it. It was great entertainment. You had an impartial jury, and it was a jury of the state and district wherein the crime was committed, which was in Waukesha in Wisconsin. Um, and you were informed of the nature and cause of the accusation. You were confronted. You confronted witnesses because you cross-examined. And you had a process of obtaining witnesses in your favor, which happened to be the prosecution's witnesses that they didn't call. And they sunk your defense because you didn't have sense enough to actually read and prepare for your trial. But we'll get into that later.
Just that stipulation of my Sixth Amendment and no other stipulation of my Sixth Amendment.
Your Sixth Amendment right to counsel is pretty straightforward, sir. You have the right to an attorney. You have the right to represent yourself. Those two things don't always go hand in hand. In fact, never go hand in hand. Sir, you have raised a phrase throughout the last 2 days that has very specific meaning to this court, and I believe to you as well. You have used the phrase in pro per. That is a shorthand way of saying in propria persona. That comes from the Latin phrase, which means in one's own proper person, also referred to as pro per or pro se. I presume that when you use that word, you are doing so intentionally. I told you the Latin phrase that it comes from, or the meaning. In a court of law, it has a specific meaning, and it is used when a person represents himself or herself without a lawyer, meaning without the assistance of counsel, without the assistance of an attorney. When you use that word, sir, it is no different from the phrase pro se.
So here's what was important about him choosing pro per or in propria persona over pro se. This goes to a pseudo legal term that sovereign citizens love, and it's a theory called the straw man theory. Okay, so the theory holds that individual has two personas, one of flesh and blood, and the other is a separate legal personality. So they think that an individual's debts, liabilities, taxes, and legal responsibilities belong to the straw man rather than the physical individual. So that's why he keeps saying he wants to represent himself pro per, because as you heard the definition of in my own person, that's why he's saying this, because he believes that pro per means that he gets to represent himself as his own person and not as a person, an idiot practicing law without a license, basically. See the distinction? And how the shit makes no sense? None. No sense.
The use of that phrase by you, sir, is a clear indication to this court that you want to represent yourself without the assistance of an attorney. Did you hear me advise you of this just now, sir?
Yes, and I'm aware of that same definition by the Black's Law Dictionary.
Right, because that's law. The Black's Law Dictionary.
Let's go back to the form, sir. We went through this section about what it would mean to represent yourself and what a judge cannot do, what a DA can't do. And then I further went over many of the challenges and obstacles you would face. Underneath the various statements on this form, there's a statement that on the form reads, check this box if you have read and understand the above. On the form that's been submitted to the court, it reads, check this box if you have read and am informed of the above. Do you see that?
Yeah, I see it.
He's not even paying
The
attention.
box has a check mark. Did you place that there, sir?
Yes, I did.
Sir, it appears to me that you read through this form very carefully. Is that true?
No.
Yes.
You clearly changed words on the form, right?
Yes, for a reason.
Yep, the magical reason.
It appears to me you did not have any difficulty reading the form and being aware of the contents. Is that also true?
It's true to an extent where I put please elaborate first on one of them. That was the only thing that I had a question of.
Sir, I cannot give you legal advice. What I can tell you is You are required, if you represent yourself, to follow the rules of evidence, the rules of procedure that are spelled out in the Wisconsin statutes no differently than if
You
you
know,
were an attorney.
if I was a licensed attorney, which I'm not, which means that that would be pro se and not pro per.
Sir, they mean the same thing. I don't frankly care what you call the terminology you
At the same
use
thing.
has the same effect. You either have an attorney or you do not.
He's
You
shaking his
hear me
head.
say that.
I'm aware of that.
So he's shaking his head, saying to the judge, "You're wrong. You're wrong. No way. You're wrong." And she's explaining that you cannot run roughshod in a courtroom, say and do whatever you want to do because you're not a licensed attorney. You have to follow rules. And because you're ignorant of those rules, you're going to have a hard time. That's what she's trying to tell him. It's just over his head. He can read and understand English, but there's no comprehension anywhere. Anywhere. There's no comprehension, period.
Underneath that last checkbox, there is a paragraph that reads as follows. I am making this decision to represent myself knowingly and voluntarily. No one has made any promises or threats to me, and no one has used any influence, pressure, or force of any kind to get me to not ask for an attorney. No one has told me I should not ask for an attorney to represent me. Do you see that?
Where it says I am informed of the court process involved in my case, that part. The top part.
Jesus Christ.
Underneath the last checkbox that we went
See,
through.
I see it.
You see it?
Yep.
Remember reading it?
Yeah, I see it.
There's another paragraph, and it appears to me that you read it and that you changed the word understand to am informed of or on. Do you see that?
Yep.
Says, I have read or have had read to me this entire document. I've truthfully answered and am informed portions of this document. I'm informed of the court process involved in my case so that I can adequately represent myself. I want to represent myself. There's a handwritten notation. I do not give up my right to assistance of counsel. Will explain reason. All rights reserved, and there's a signature. You see that, sir?
Yes.
You sign this document, sir?
In my true name, yes.
Ah, in his true name. So it's signed in his true name because we're doing that straw man thing again. So he believes that when a baby is born in the U.S., a birth certificate is issued, and we get parents apply for a Social Security number. The sovereign said that the government uses that birth certificate to set up a secret treasury account, which it funds with an amount ranging from $600,000 to $20 million, depending on whichever sovereign belief system you believe in. So every newborn's rights are split between those held by flesh and blood baby and the corporate shell account. So when he's always screaming about, I don't consent to that name, that's not my name, in his mind, that is the corporate shell account, not his true name, which has to be written in a special type of way. So that's the bullshit that he's talking about. Nonsense.
Sir, anyone make any threats or force you in any way to sign this document?
No.
Anyone make any promises to you in exchange for signing this document?
No.
You understand, sir, that by signing this document and presenting it to the court, you're asking me to accept your waiver of the right to an attorney.
Just so I'm clear, that would be essentially just that part of my Sixth Amendment, correct?
Idiot.
The right to an attorney, yes.
Just that part.
We are just talking about the right to an attorney, sir.
So essentially, the rest of my Sixth Amendment right is preserved.
That is correct.
Thank you for clarification.
Jesus Christ.
Sir, do you wish to waive your right to an attorney?
Yes.
So, we heard it. Do you wish to waive your right to an attorney? Yes.
Anyone make any threats or force you in any way to waive your right to an attorney?
No.
Anyone make any promises to you in exchange for you waiving your right to an attorney?
No.
You understand, sir, that means attorneys Keys and attorney Perry will be discharged from this case.
Yes.
You are aware that means they will be discharged from representing you.
Yes.
You are aware they will not join you at that table after that decision is
I am
made.
informed, yes.
Do you believe you are making the decision to represent yourself knowingly and voluntarily?
Yes.
Do you believe you are fully informed about the advantages of having an attorney represent you?
Repeat that again.
Playing
Do you
games.
believe you are fully informed about the advantages of having an attorney, someone licensed to practice law in the state of Wisconsin, represent you?
Fully informed, yes.
Do you believe you are fully informed of the disadvantages and challenges of representing yourself and acting as your own attorney?
Yes, I am informed.
Uh.
I went through this a little bit, sir. And while I know you have not asked for an adjournment, I want to make a few things clear if I haven't already. This court feels compelled to advise you in advance of a final determination by the court that this trial needs to take place in October of 2022 due to significant steps to secure a jury. This includes the extra jury pool. By that, I mean initially summoning approximately 1,600 qualified jurors, setting out what we call the initial qualification questionnaire, followed by a case-specific jury questionnaire sent to the vast majority of those 1,600 individuals.
Nigga, sit still.
In addition, this trial was scheduled 6 months and 22 days. Will be 6 months and 22 days on October 3rd, roughly 6.5 months. It was scheduled on March 11th. We've had significant litigation to date, including a motion to change venue, a motion to adjourn. We've conducted significant hearings regarding the jury selection process. This court heard and decided a motion limiting other acts. This court dismissed 6 counts upon the motion of your attorney.
So, the motion to eliminate other acts, that means that him beating on his ex-girlfriend, trying to run her over with the car, um, being a sex offender, impregnating his ex-girlfriend when she was 15, and he was 23. These are things that would be highly prejudicial to a jury. So the defense wanted to have all of that suppressed because it is the probative value does not outweigh the prejudicial nature of that evidence. Now, if Brooks brings it up in any way, then the prosecution can go into it. But generally speaking, since they have ruled that that is improper, they're not going to discuss it. Now, in a trial, numbnuts is stupid. He doesn't understand about asking questions to elicit the response that he needs to get because he hasn't read anything and he's just making it up as he goes along. He opens the door all over the place. And lots of prejudicial information gets leaked into this because of him.
This court set aside 1 month in October of this year to try this case. The sheriff's department has set aside this time. There's extra personnel that's been required from the clerk of court's office, the sheriff's department, just due to the high publicity of the case, the number of people involved, etc. Did you hear me advise you of this?
Yes.
Knowing all of this, is it still your desire to waive your right to an attorney?
Yes.
So she's telling him, don't complain, saying that you're not prepared. Don't complain that you by yourself and you don't know. I'm informing you that this trial is going to start on Monday. There is significant pressure. It's pressure for me politically. It's got I have to get reelected. And all the people in this town wants your ass. And I have to get this handled before the 1 year anniversary, or it's my ass. And it's not going to be my ass, it's going to be yours.
Attorney Perry, anything you want to add to what I've questioned Mr. Brooks on at this time, or any other information you think I should know?
We will promptly give Mr. Brooks preparations that we've done for trial. We'll have delivered to him, and I understand that the jail is going to be working to make electronic discovery reviewable for him and taking all those steps.
From the state, anything you'd want to add to the record at this point, Attorney Opper?
Yes, Your Honor, thank you. There's a couple of points, please, if you could indulge me here for a minute. The court has certainly been very thorough. There's just a few things that I would like that we could perhaps drill down on just a tad bit more. My concern is on the form that you've just spent extensive time going through with Mr. Brooks. There's application at the very bit, and again in the middle part, suggesting that Mr. Brooks has the right to an attorney at any time of the proceedings or any time during the proceedings. You have been very clear here with him that that's not absolute. So I just would like him to be advised that he can't flip-flop. He can't get into the trial and decide on day one he wants a lawyer and then change his mind back and change his mind back again. I think he should be advised of that, because the form does say I may change my mind at any time on the second sentence of the form.
You got to pick a
That
side.
needs to be made abundantly clear to Mr. Brooks that that's, I believe this form is used largely in the pre-trial capacity and not the week before trial. So
Got to pick a
I would like
side.
the court to please advise him of that.
Mm-hmm.
Do you want to do these one at a time, or do you want me to?
Sure, I think that's
Okay.
a good idea. Yeah, Mr. Brooks, did you hear the state's concern as voiced by Attorney Opper just now?
I think you were pretty clear in what you advised me of. I think you made it very clear that it would be challenging, but not impossible. That was your exact words, verbatim. So what needs to be made abundantly clear when you've already done that?
Well, what needs to be made abundantly clear is that your ass is hey, no hurt. Your ass is sweet meat. That's what you need to understand. That's what they're trying hard to get you to understand. A man who represents himself has a fool for a client. That's what they're trying to get into you. But you don't understand the relevancy, according to you.
Thank you, Mr. Brooks. Um, One of the challenges of being judge is I can't give advisory opinions, right? I can't give advice, but in the context of waiving your right to an attorney, I think it's important that you understand exactly what Attorney Opper has just said, and that is this form is generally used in the pretrial context, not at the 11th hour on the verge of a trial starting. You are correct. It's not impossible. It's incredibly challenging. I told you a couple of the cases that I would need to consider. But what I would further tell you and advise you is that the right to an attorney is not absolute, and that's from the case law. Once waived, the Sixth Amendment right to counsel is no longer absolute. And I'm looking at the Wisconsin case of State versus Rhodes, citing to the United States versus Salina, and other cases from various circuits. That was a Seventh Circuit case, but Menfield versus Borg, Brown versus Wainwright, Merchant, United States v. West. Those are all cases that are cited by Rhodes. And
Baby, he don't know what you're talking about.
State versus Lomax. There's also State versus Lovetto. And these are some of the considerations that I would need to consider if it were raised. And that includes practical concerns of managing its docket. That's my concern. Impact that a request may have on its general responsibilities for the prudent administration of justice, the timeliness of the request for substitution of counsel. All of these cases are substitution of counsel cases, but the case law makes clear that when a pro se person seeks to now, however you want to call it, sir, in pro per person wants to request an attorney, I treat that as a request for substitution of counsel because you're acting as your own attorney. I think you understand that because we've discussed it, you've acknowledged it, but did you hear all of the advisements just now?
I heard the advice.
Any questions for me about that?
No.
All right, Attorney Opper, the next.
Also, I think you have made it abundantly clear, but you touched on the idea of co-counsel or hybrid counsel, that obviously once he's allowed to self-represent, there will literally be no one sitting next to him, not as if he can ask some questions and another attorney sitting next to him can ask some questions, or they can share responsibilities or duties.
There's another complaint that he has.
Thank you. Mr. Brooks, did you hear what the state just said just now?
I heard it, and again, I think, like was just stated, you were abundantly clear on that issue as well.
We talked some yesterday about some of the challenges. You would agree with that?
As far as it
Representing yourself. And I'll be a little more specific. Yesterday, I went through the experience of not only your own attorneys, but the experience and the resources available to the state. Do you remember that?
I do.
I may not have said it this way, but one of the things the state will be able to do is there are 3 attorneys seated at that table. They can divide and conquer the work between them. Did you hear what I said?
Yes, ma'am.
You're fully informed about that, correct?
So she's telling you that they're going to tag team your ass. You're going to have 3 killers coming for your head. That's what she's trying to tell you. You got a tag team here, Triple H here, coming for your head. And you over here trying to flirt. He's trying to flirt.
And I'm going to just, I know you don't like this word, but you understand you're going to be sitting at that table by yourself, right?
I'm not alone, I don't think.
There will be no attorney seated
Look at
next to you,
I know
correct?
what you mean. I know what you meant.
All right. You will have the sole responsibility
He
to
flirting.
cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that.
I am informed.
Any questions regarding that?
Not at all.
Not at all.
Now for your next point.
Thank you. On the second page of the form, you did touch on him under the section that reads on the form. I understand that if I represent myself on the 5th bullet, he wrote in there, please elaborate first. I believe you did elaborate on that and further told him that you're not allowed to provide legal advice to him, but I didn't know if there was a specific question that Mr. Brooks had that perhaps the court could address, perhaps not, if it hinges on legal advice. But
Fair
it was
enough.
a little bit ambiguous what he wrote there.
Fair enough, sir. You obviously wrote some things on this form. Do you have any questions for the court at this time regarding this form?
I think you touched on it a little bit on what the question would have been, and that was basically just the stressing that I did of the pro se thing, because essentially, from my understanding, is that pro se, in a sense, because I would be basically like I'm a licensed attorney, so that would kind of limit what I'm able to do versus being pro per.
I don't understand where he gets this shit from. Where do you get this from? Yes, you're going to be limited to what you can do. It's called rules. We all have to abide by them. You can't just do what you want to do. Oh, well, I'm not a licensed attorney, so I can just do whatever I want to do. No, no. Who told you this?
You touched on it a little bit and gave me a little
Sir,
bit
I'll
more
tell you, it doesn't matter what you refer to yourself as, whether it's pro se, pro per, in Priya persona,
You fucked.
you will be acting as your own attorney. And I believe you fully understand that. I want to go back to the box that you did not check, though. Given everything that we've discussed here today, do you have any questions regarding the section regarding what an attorney would do on your behalf? And I don't mean you acting as an attorney, but a licensed attorney in the state of Wisconsin assigned to represent you.
Yeah, you touched on it. I think it came up like right when I had voiced that, and you kind of clarified it.
Understanding that this section refers to a licensed attorney in the state of Wisconsin, would you be willing to check this box now? That you have read this section and that you are informed of the above.
Yeah, I'll check.
Look at him
You have
flirting.
the original. I'm going to ask that if you're willing to do that, that you do that, initial it, and date it.
Quick question on that. What is the significance of the initials and date?
God dog.
As it pertains to
For me,
not having to do that for the I think you know what I'm saying.
for me, the form that I have was signed yesterday, the 27th, today's the 28th. It's an indication anyone reviewing it later Madam Clerk? The record should now reflect, I do have the original, which actually is a little bit easier to read than the scanned version. And Mr. Brooks did check the box that was originally left unchecked. There appears to be 3 initials and then today's date.
Can you hear it now?
Thank you. Attorney Opera, your next point.
Last point does relate to the form, and it goes with what just occurred.
Okay, good.
At the bottom of the form, it states in all bold letters, this form shall not be modified. It may be supplemented with additional material. I think that's standard printing on the form, but I just want Mr. Brooks to be aware that obviously you are accepting the form as modified by him at his request, so that there's no question later that you accepted the form contrary to the printing on the form that says it should not be modified.
So basically what she's saying is this form was altered by you, by him. That is, the form should not, according to what the state issued, shall not be modified. You can have supplements added to it, but you cannot write all over the form and think that that is going to start some sort of tacit agreement. Didn't work that way. Which is another argument that, well, you still can't hear me?
Thank you for bringing that up as well. I certainly understand that. Mr. Brooks, you would agree any of the changes that were made by you and not this court.
Yeah, I mean, I feel like we've covered everything dealing with that form. I don't understand the relevancy of stressing the form that we just spent so much time going over. I think you were more than clear in your advisements of exactly what the form meant. And I think you were pretty clear.
Thank you.
So, pretty clear. Pretty clear. The form is pretty clear. I understand. He understands the form. I guarantee you, when we get to it, he's gonna whine for 50 minutes straight about he didn't understand the form, and because he marked out I understand and put am informed, that should have been an indication that the court should have known that he didn't understand. Even though they're asking him, do you understand? Do you get it? And he's saying, yeah, I don't know why we're still talking about this. You explained everything to me, and it's all clarified. That's why I can't stand this dude.
Is that it, Attorney Opera?
That's it to the form. I would request an opportunity to be heard on the motion prior to ruling, or if you're going to defer ruling.
No, I am going to rule. I will certainly give you an opportunity to make any statements you want before I issue a final decision. So go ahead.
The only outstanding issue, Your Honor, we have not yet spoken of it today on the record, was the letter that was filed by the defendant's mother. I believe it came in late yesterday afternoon or first thing this morning, in which she has indicated she thinks Mr. Brooks is not competent to be making these decisions. I just wanted the record to reflect that we've reviewed.
So his own mama wrote to the court I know the video's low. I can't make it any louder. But even his own mama wrote to the court and said that he is not competent enough to be his own attorney. He has a personality disorder, and he also has a bipolar disorder, and he has not been getting help with these mental disorders, and he's going to act a fool in court. He's going to be manic, and he's going to rage, and he's going to build a well, she didn't say that he's going to build a box fort. He's going to be childish. He's going to act out, be aggressive, all of that. Mama said, don't let him do this. Don't let him do it.
The history of offenses for Mr. Brooks in the state of Wisconsin. We know he has a record outside the state of Wisconsin, but we have not been able to develop that. First, the record should reflect that he is experienced in the criminal justice system. He has been charged and convicted and sentenced for prior felony offenses. He's been through the court system on at least 10 prior occasions, or 10 prior cases, I should say.
So the attorney opera is saying, look, this dude is a career criminal. He has been to court about 11 times. He been in that seat before. So he understands generally how court works because he's been here enough. He's been in court more than I have. And I did get probation in court this much. So he got cases from all over the country. Cases. Beating bitches, running over bitches, all over the place. So he knows. So he can't say ignorance. I didn't know how this goes. I'm confused. You're a career criminal, sir. You know. You've been in the criminal system since you was what, 16, 18?
The state of Wisconsin. The majority coming from Milwaukee County, one from Wood County, one from Manitowoc County. We could not find on any occasion, searching court records available online, a situation where Mr. Brooks had competency was ever raised, or he had claimed himself to be incompetent, or counsel or the court had ordered an evaluation for competency been an issue in any of his 10 prior cases.
10 cases.
We're also aware of the NGI evaluations that were performed in this case. It's certainly a different issue.
NGI just means not guilty for not guilty by reason of insanity.
Competency versus insanity, but they were all licensed professionals, psychologists and psychiatrists, in my professional opinion, would have alerted the court if in the course of their NGI evaluation, they thought there was concern as to the competency of Mr. Brooks. That did not occur as well. Lastly, I would note, and Attorney Perry touched on this at the beginning, he started to touch on it, that Attorneys Perry and Keyes apparently have never felt that competency was an issue or needed to be addressed by this court. It has not been raised by them. The court record here is clear. I've been at every court appearance. I have never had any concerns of Mr. Brooks' competency. He appears to me to be intelligent. He appears to fully understand what's going on in these court proceedings. He has the ability to communicate efficiently and effectively with the court. He has responded to the court. Some of his answers seem to fall more in line with his declaration yesterday that he's a sovereign citizen, but he has always participated in the court proceedings and never appeared to be in such a manner that he was not able to understand or assist in the proceedings. So I just wanted to make that record as well.
Now listen to what this dumbass is going to say after this. Now the attorney is saying that he seems to be intelligent, articulate, which I don't know where they keep getting articulate from, but articulate. He does not have any like learning disabilities. He doesn't have any competency issues. I've seen him in court with my own eyes, with my observation. I don't see anything that would determine that he was incompetent, mentally incompetent. His own attorneys have not shown or said, and felt that he would be mentally incompetent. He's been um, evaluated by 3 or 4 PhD psychological therapists, and they have no issue with his competency and his ability to understand. He's had a multitude of cases. He's got 10 cases. He's got a pending case now in Wisconsin, Milwaukee, that he's got to go to in a couple of weeks. Okay. So he's been to court. He's a career criminal. He's a thug. So he knows how this goes. So I don't see any problem with you granting his request. That's what she's saying. That's what she's saying. Let's see what he says.
And I think that's it for my comments, Your Honor. Thank you for the opportunity.
Thank you. Mr. Brooks, anything you want to add to the record at this point regarding the request?
Yeah, yes, I do. I'm trying to grasp the relevancy of that whole issue,
Moron.
especially the part that was just said about me participating in everything, seeming to know everything that's going on in the proceedings up until this point. Kind of misleading a little bit, I think, by the state, because I recall it being an issue when the whole misunderstanding happened in court back in last month,
Haters.
the 26th, if I'm correct. It was a whole issue about me being quote unquote asleep in court.
So this white woman has sat here and said that Mr. Brooks is intelligent and he's capable. And there is nothing that he will not be able to grasp and understand. This dumbass objects to it and wants to be petty and talk about, well, we had a misunderstanding a couple months ago, and she said I was asleep in court. So I don't know why she's bringing this up now. What? She said that you smart, which I don't know why they keep saying that, but she said that you smart. You is smart, intelligent, you is wonderful. And you say you object.
So I think that's kind of
Stupid.
misleading to say, to raise all the competency things I was in, intelligent and all these things, and then raise the same things. That's kind of like a clash.
He's
I don't
stupid.
understand that. I don't understand the relevancy of it.
Stupid.
I don't understand the relevancy of
It's relevance, nigga.
the NGI plea being referenced to when that plea was essentially withdrawn.
See what I'm talking about? Stupid as fuck. She's saying you're not crazy. The plea was withdrawn and you were observed and evaluated by the people who, when you were doing your plea, they had to evaluate you to determine your competency. And they said that you aren't crazy, is what she said. God.
I don't see the relevancy of prior cases with this case in front of you now. I don't see the relevancy.
Because you're stupid. That's why.
I think you're more than capable of making the right determination based by what you have in front of you now.
Thank you. Before this court gives a final decision, I want to go through a little bit of the procedural history of this case, not long, and then some of the case law, because it is important as this court decides this very important issue. So as everyone, I think, is aware, the Waukesha parade occurred on November 21 of 2022. I believe it was 2 days later, on November 23, that charges were filed.
Year was 21.
Did I say 2022? Thank you. We're in 2022. Thank you. Um, 2021 is the incident. This case is 21 CF 1848. There's been a significant amount of litigation in this case already. There was a contested preliminary hearing. Then the first appearance occurred before Branch 2 on March 11th of 2022, about 202 days ago. It was on that date that this court set aside the month of October to hold the trial. The first trial order was issued. Many of the dates were discussed, but the trial order wasn't issued until April 11th of 2022. That is when it was formalized. Going back to the March 11th date, though, a decision was used on that date to utilize a jury questionnaire, meaning a case-specific jury questionnaire. There were related deadlines that were discussed. On March 29th, we held a hearing to discuss the questions and finalize the questions.
All right, basically she's saying, look, we did all this stuff in order to get you here, and it's fair. The jury's impartial. You don't have to worry about, we've packed the jury full of a bunch of Klansmen. That's what she's trying to establish. But at the end of the day, long story short, she releases these two grateful people from their burden, and so you get to see them. Well, not in this video, but they walk off happy and going into the sunset. But I want to show one thing before I end it. And let me find it here. Oh, that's the wrong thing. Let's see. Let me switch accounts real quick. It's one thing I want to show. I want you guys to see what he did, because I found a video of him actually running people over. Let me find it here. I have so many videos because I'm rewatching everything in order to get timestamps so I can discuss it. Let me see here. But every time I hear him talk, it reminds me of when I was in law school, when we did not, if you didn't understand something and you weren't prepared to discuss it, you would just bring up all type of random stuff just to throw anything at the kitchen sink. And one of the mantras of, oh, here we go. One of the mantras of school was, just answer the damn question. And he's not in the answer the damn question category. He is, I'm going to run my mouth continuously. Okay, so I'm about to play this. This is what he did. Oh, hold on. That's the wrong video. Wait a second. Crap. Hold up. Damn it. This is annoying as hell. Hold on. Look, I'm a little bit rusty. Y'all forgive me. I'm a little rusty on my stuff. I hadn't been live streaming in 6 months, so please forgive me. Please forgive me. I thought that was it. That's the wrong one. because that's the video. I got a video where he actually runs into people. Okay, I think this is it here. Yeah, this is it. Hold on. I apologize. Okay, it's age rest. What? Okay, what? I understand what you perceive. Y'all see that? This is a person on the hood of the car. And you see he runs over people here. Let me slow this down. This is what this fool did. I can't remember. This is speed up or slow down. I can't remember. I think this is. I'm sorry. It's been a long time. This the parade now. On the hood. Hey, Scratch of Hope. On the hood. Oh, has a baby just like Prince. Oh, I need to go see that. But on the hood. And ran over him and kept going. He continued to go. You see this? These are people. Look, the car is bouncing up and down. He ran over a child, an 8-year-old child, and injured 61 other people. $61 other people. That's what he did. That's what he did. Well, he's never going to be free again because, again, he had over 1,000 years that he's probably, they're probably going to sentence him consecutively and not concurrently. There's no way he's getting out of prison. And he had no remorse or empathy. He played the, well, that's not me game. He has so many BS defenses. But we're going to get into that. I'm going to go into the first day hysterics next live. I'm just going to pick like key points from each day and discuss it. You know, what I found to be interesting, and that he had no defense of any kind. I mean, nothing to try and have any reasonable doubt that he intended on doing this. No defense period. It was just it was just a cluster. But anyway, that's gonna be it for me this evening. It's almost been 2 hours, and it's time for me to get my little Tushy in the bed. So I will come back at another time with my part 3, and I will be going over the first day of trial and him acting like a baby and a brat and being kicked out the courtroom 11 times. Anyway, so let me go ahead and wish you guys a wonderful rest of your week, a wonderful weekend. Happy belated Halloween. I had such a good time with trick-or-treating with the little childrens. I had so much fun trick-or-treating. I wish I could have showed it to y'all, but stuff. But anyway, I'm out of here. Have a good night. Hugs and kisses to everybody. Let me see. I don't even know what. Oh, here's my outro. Okay. Bye, y'all.
Drums, please.
Ladies and gentlemen.